Good morning, Your Honor. Nicole Underwood, legal guardian at the minor child.
Ms. Sasha Thomas, counsel for the department. Ms. Kelly.
Brittany Kelly for the department.
Michael Brooks, I represent the father, Harold Hollis. Harold?
Oh, yeah. Michael McFarland representing the mother. Please introduce yourself. Did the court hear that?
Nope.
Aaron, go up here.
Thank you. All right, it looks like Ms. Walker was on the stand at the last juncture. Did anyone have any further questions for her before we move on to our next witness?
I did not.
No, Your Honor.
Not at this time, Your Honor.
Ms. Thomas, your next witness.
Your Honor, may I inquire if Ms. Renee Moore is online? Yes. Your Honor, at this time, I would ask the court to allow for the LGL to call her so she can return to work.
Any objections? Gentlemen, any objections?
No.
No.
Very well. All right, Ms. Underwood, you can take the helm there. You might want to, yeah, I was going to say, go ahead and use the podium.
Like you're sworn in, Your Honor?
Hmm?
Like you're sworn in?
Yes, but I don't know if you, Ms. Underwood, do you want the podium moved to point towards the camera? That would be to your
Well, I guess
right.
we'll find out.
As you can see, you're kind of sideways. It doesn't matter to me. But we can move that podium so that you're facing the right.
Either way is fine.
Okay. Yes, please swear in Ms. Renee Moore.
Good morning, Ms. Moore. Can you hear me okay?
Yes, ma'am.
Could you please state your full name for the record?
Renee Moore,
And Ms. Moore, where is it that you work?
Moore Counseling Services, as well as Reading School District.
Okay, and what is your job title?
Therapist, licensed master's in social work.
And how long have you been a therapist for?
18, 19 years.
And how do you know the Hollis Walker family?
I did an assessment on Mr. Hollis.
Okay, and that was regarding the minor child?
Correct.
Okay, and you did provide a written report to the court regarding your recommendations for parenting time, is that correct?
Correct.
Did you schedule appointments with Ms. Walker to attempt an assessment?
Correct.
And how many appointments did you schedule with Ms. Walker?
Your Honor, I'm objecting. There's no court order that my client attend any appointments. The court is not taking jurisdiction. She's not required to make any appointments. So it's.
Your Honor, this is in response to any recommended parenting time that may occur if the court does take jurisdiction. So I believe it's relevant for at least those purposes.
Ms. McFarland, I believe I ordered an evaluation on counseling. I'm just looking through my past.
So am I, Your Honor. So I may have misspoken, but I didn't see it. Look.
I know I had asked for a recommendation on parenting time, given the allegations that were contained in the first court order after the hearing conducted by Judge Costello, considering that I had not presided over that, and that there were still some unanswered questions as to whether or not it was safe. So I'll rule your objection because it's important to understand why and whether or not your client cooperated with that.
Ms. Moore, so how many appointments did Ms. Walker no call, no show for?
2 appointments. August 18th, 2024 and August 29th, 2024.
And you were able to meet with Mr. Hollis?
Yes, on August 16th of 2024.
And you were able to watch him interact with the minor child?
The minor child was not there. I was there to talk with him and do an assessment on him.
I couldn't hear that.
Yes, Ms. Moore, could you get a little closer to your microphone? I think it's not picking up quite all of your statements there.
I apologize. I met with Mr. Hollis. I did not meet with the minor child. I just met with the parent to do an assessment for parenting time.
Excuse me, Your Honor, because it's a little distracting. Is that a horse with the witness?
Your Honor, that is Miss Moore's therapy pony that is there in the school, so.
Oh, it's just distracted me. I'm looking at it thinking, what is that horse doing there?
I apologize. I can see if a teacher can take her if you want me to.
No, I just never seen a horse in testimony before.
Trying to keep her out of the
Your
picture.
horse is fine, ma'am. Your horse is, I have no objection to your horse.
This is the first,
Any other objections to the horse?
No, we welcome
No,
the
Judge.
horse.
as long as he doesn't contribute.
All right, you may proceed with your next question.
Oh. Thank you for the clarification, Ms. Moore. You indicated that you were just there with Mr. Hollis.
Correct.
Okay, and what concerns do you have with respect to Mr. Hollis's ability to parent the minor child?
He expressed during the assessment how he had a heart condition. I could hear him wheezing. He talked about having difficulties with the walking, and he was being evaluated for yet another heart surgery. So I wanted more information as to his medical clearance because of the way that I could hear him breathing. My
Do you
concern.
have, go ahead.
My concern is his physical ability for a child, that's as young as his daughter is, to be able to keep up and move around and not hurt himself.
Your Honor, I am going to object in that I've not heard her qualified as a physician or anybody qualified to make those physical, medical statements.
Your Honor, I would respond and say that Mr. Hollis is the one that notified Ms. Moore of his health conditions. She was not making any diagnoses, just noting concerns.
Yes, I think I'm not taking her as an expert in the area of medical diagnoses, Mr. McFarland. And she is, however, an expert recognized for purposes of counseling as well as parenting recommendations. And that request for recommendation on parenting time was given to her, and it is relevant. The health concerns would be relevant for purposes of parenting time and parenting ability, which is how she has couched her inquiries. So for those reasons, I would overrule the objection. Does anyone else want to argue on the objection or raise a different point?
I support what Mr. McFarland said to the extent she's making diagnosis or assumptions based on medical knowledge. I object.
Fair. All right, overrule. Anyone else?
No, Your Honor.
All right, thank you, Ms. Underwood. And Ms. Moore, if you need the question repeated, great. If you want to keep going, also great.
Thank you, Your Honor. I'm not a medical expert. That's why I asked for further information to assess the parenting ability to keep up with the child instead of, because I don't want somebody who sits in a chair and says, come here, come here. I want a parent that can actively engage with a child.
Ms. Moore, do you have concerns regarding domestic violence in the home?
Mr. Hollis denied the allegations. I did have a police report that we reviewed together, but he denied the allegations.
Okay. After your assessment of Mr. Hollis, what is your current recommendation with respect to parenting time?
I had asked for further information on his health. I asked him to engage in counseling, individual counseling, to address potential domestic violence, parenting, and substance abuse as indicated in the report, and then start off with 1 hour supervised visitation.
Okay, and you did submit counseling reports to the department, is that correct?
Correct.
Your Honor, Ms. Moore's reports have been submitted and circulated to all of the attorneys, so I would move that Ms. Moore's recommendations be admitted in evidence.
I think they were admitted without objection already.
I don't know that that was accomplished on record, but do you have any objections, Mr. Brooks?
No,
Mr. McFarland?
No position as my client. No.
Ms. Thomas?
No objections, Your Honor.
Thank you. All right, they are received as a wing of the court moving forward on, and I found it in the orders. It was actually issued by Judge Costello back in June for counseling to determine appropriateness and conditions of parenting time. A trauma assessment was also noted. So for those reasons, they are admitted.
I have no further questions, Ms. Moore, but the other attorneys might. Thank you for your time.
All right, Mr. McFarland, any questions?
No.
Mr. Brooks?
Ms. Moore, forgive me, and I don't mean to make light of the situation, but I need to know, what is your horse's name?
Dazzle, this one is Dazzle, and I also have Boots that goes to the elementary school.
That's all I wanted to know, ma'am. Thank you.
So Dazzle and then Boots is at the elementary school, is that what you said?
Correct.
All right, and I'm only asking because it's still a little bit hard to hear you. All right, any questions, Ms. Thomas?
Good morning, Ms. Moore. Thank you for joining us today. I just have a couple of questions. As relates to your attempts to schedule with Ms. Walker, you stated that, can you just clarify, were two appointments scheduled and she did not attend?
Correct.
Do you have any concerns about a parent who does not attend a mandated or court-ordered session with you?
Motivation to modify the reasons that they came to court would be a concern.
Thank you. I have no further questions, Your Honor.
All right, any other questions for this witness from any of our attorneys?
No,
I do. Ma'am, you, basically, if a parent doesn't show, you don't know if that's because they have lack of transportation, whether other situations other than just a refusal to cooperate. You don't know that from them not attending, correct?
If they choose the time in the day, then the basis would be that they have that available to him, to the person. But that is correct. I would not know, but I give options of days and times, and then they pick. If that makes sense, what I do.
Right, but you don't know the conditions in which a person did not show up, correct? You're speculating what it might be by them not showing, correct?
Correct.
Nothing further.
Mr. Brooks?
no, thank you.
Ladies?
Nothing. Just one follow-up, Ms. Moore. Did Ms. Walker indicate or contact you and explain any reason why she couldn't attend the appointments that she scheduled?
No, ma'am.
Thank you. No further questions.
All right, any reason we should not thank and excuse Ms. Moore?
No objection.
No.
All right, you know what, I'm sorry, I do have a question. Ms. Moore, I know you know this, but the court is required to look at parenting time suspension only in the event that it may be harmful to the child. Do you see any reason, and I know you didn't get to meet with Ms. Walker, but based on your review of the case, do you see that there's any harm to this child, and would you want more information in order to make that determination?
I can't make a determination on Ms. Walker because I have not spoken with her. With Mr. Hollis, if it's supervised, you know, as I outlined in the recommendation, supervised for 1 hour, then you can go from there. Assess if he's able to parent and the child has a bond with him.
Would you be able or willing or have room on your calendar to facilitate that for him?
I could do that.
Thank you. Any questions based on my questions?
No, Your Honor.
No, nothing about you.
Mr. Brooks, any questions?
I'm sorry, Your Honor, my client was,
That's all right.
and no, I have no further questions.
Ms. Underwood.
No questions.
All right, thank you so much for your time and your testimony, Ms. Moore, and that's all for this morning. You're welcome to be on with your day.
Thank you.
Right, your next witness, Ms. Thomas.
Thank you, Your Honor. I'll call Ms. Kelly.
All right, Ms. Kelly, come on, please.
Good morning, Ms. Kelly. Can you state your full name for the record, please?
Brittany Kelly,
And Ms. Kelly, where are you employed?
Department of Health and Human Services for Child Protective Services.
And how long, what is your job title there?
I'm a CPS investigator,
And how long have you been employed with the department?
5 years.
And have you been a CPS investigator for those 5 years?
Yes,
And you signed the petition that's before the court today, correct?
I did.
Can you tell us a little more about how you became familiar with the Walker Hollis family?
I was assigned an investigation due to concerns of domestic violence. I attempted to meet with the family multiple times. Did meet with Harold on several occasions. Then I was able to meet with Harold and Erica at the same time, where we discussed the allegations and safety concerns. They did cooperate in that meeting. We attempted a safety plan. They would not sign the safety plan or finish the safety plan regarding domestic violence and substance use. They denied all the allegations. Based on the information I gained throughout my investigation, the case was open. I attempted a family team meeting. Mr. Hollis did participate in that. Erica did not participate. I attempted to engage with her several different times to set up meetings, to meet with Melanie, and to start services with the family.
Do you recall about when that family team meeting was that you, or I want to go back to dates. Do you recall about when you would have met with the parents to discuss the concerns about the complaint?
I believe it was the beginning of April or the end of March.
In your petition, you indicate that the complaint came in on April 15th. So when did you?
So it would have been within, we have a time frame to see children, so within 72 hours, I would have had to see Melanie.
Were you able to see Melanie within those 72 hours?
I was not.
What attempts did you make to see Melanie within those 72 hours?
I personally made multiple attempts to home visits. Harold was at the home most of the times. When I spoke with him, he did not have any knowledge of where Erica was, but just stated that Erica had Melanie and they were gone. We sent our CPS on-call worker out after hours to meet with the family to see if Melanie and Erica had returned to the home. They had not. I attempted calling Erica several times on multiple different phone numbers. I sent her an email with the email we have from our Bridges system. I texted her phone number multiple times and I was unsuccessful.
Do you recall at what point in time you were actually able to, let me backtrack that a little bit. Within the first 72 hours, were you able to speak with Erica and ask if she would be willing to meet with you?
I actually spoke with her on the phone while sitting in the driveway 5 minutes after that 72 hours expired.
And what happened?
I believe she stated that she would let me know when she could meet with me, which then was followed up by several text messages to try to engage with her to meet with me.
And you heard the testimony of Ms. Walker on the 9th, correct?
I did.
And you heard the dates that were read off through text messages between you two?
I did.
Were there any other contacts, like whether via phone call that might not have been explored on the record, or emails?
There were phone calls in between text messages. I don't have exact dates, but they would be documented in my report.
Speaking of report, to today's trial and part of discovery, you have provided me and then subsequent through that, the other attorneys with 2 CPS investigation reports. Correct? Okay, and so we have intake 126040431, which the complaint is dated for 4/15/2024. And then there's an investigation ID an intake ID of 136020450 with complaint date of 6/19/2024. Can you explain why there are 2 different reports?
The first one was the initial investigation that had began. And then in the process of the case opening, we received new allegations that prompted a new investigation to start.
Your Honor, may I approach the witness, please? Ms. Hyman, I hand these reports to you. And if you need to refer to them to refresh my memory, please let me know if you're doing that. What were the main concerns about the family in the original complaint that you got in April 15th?
We had allegations that there was a domestic violence altercation between Erica and Harold, that the child was present and possibly may have been hit in that process of the parents fighting.
And were you able to affirm or confirm, I should say, any of those concerns?
No.
Is domestic violence in general a reason to file a petition against a family and ask for removal of a child?
Not always.
Is substance abuse in and of itself a reason to file a petition and ask for removal of a child?
No.
And is lack of cooperation with the department a reason to file a petition and ask for removal?
Our policy states that if a case is open for services and the family is not cooperative with services, that is a reason to file a petition with the court.
So help us understand. You determined that it was necessary to open a case, correct?
Correct.
What are the other options? Like what other dispositions do you have when you get an investigation assigned to you?
Well, there's 5 different categories. So category 5 would be no evidence or abbreviated case, family lives out of state. Category 4 would be a denial. So the allegations are untrue. We couldn't substantiate on them. Category 3, open close, would be they were substantiated on but provided outside resources for services. Category 3, open, would just mean that the case would be open for 90 days and monitored with this ongoing CPS worker. Category 2 would be substantiated on and open for more than 90 days. And based on the progress of the family, that would determine how long the case was open for. And category 1 is court involvement.
And at the for the first complaint, you determined that you needed to open a case.
Correct.
At what level?
Category 2.
And does that include court involvement?
Not at the initial disposition, no.
And why did you determine that it arose to the level of a category 2 and not a 4 or 5?
Harold was being cooperative, semi-cooperative throughout the investigation. There were certain things that he wouldn't safety plan around. I had concerns that the family was violating the PPO that was in place at the time. I still couldn't make contact with Erica throughout the month of May. And I felt like they needed some services regarding healthy relationships, communication skills, possible mental health, possible substance use.
Did you have any other records or files available to you when you were making that determination?
I had a lot of previous police reports. I had previous ISPs from investigations through the department.
In your report, you indicate that there are 2 reports from 2022 in which there is domestic violence, or police reports from 2022 in which there is domestic violence alleged in those police reports. Is that accurate?
Correct.
Your Honor, I'm objecting as that would indeed be hearsay. Hearsay is not permitted at an adjudication trial.
Your Honor, I'm not offering it for the truth of the matter asserted. I'm offering it as, well, I actually haven't offered it yet at all, but I'm asking Ms. Kelly about it for the basis of categorizing the case as a level 2 and not a different level.
I would still say that she's relying upon hearsay. That is not allowed. We need an actual witness who generated the report.
Anyone else want to weigh in on this?
No,
I don't believe it's hearsay because she's not referring to what's in the report necessarily, just referring to what was utilized to form a decision at the time that the report or that the petition was being filed.
Yes, I agree. The objection is overruled. Ms. Kelly is not responsible for whether or not that information is true, but rather using it in order to properly categorize a complaint that she receives during the regular course of her obligations in her capacity as an investigator.
Right. Well, Your Honor, and with that, I would move to admit the 2 police reports that are referenced in the report.
I'd like to just order the witness on one question, Your Honor.
Okay.
You're not taking an opinion as to whether these reports are true or not, correct?
During my investigation, you mean?
Right.
Repeat the question, please.
You were not taking an opinion, having an opinion that these reports were true or not, correct?
I feel like that's hard to say yes or no to. I think they weigh in on my opinion while making decisions if there are multiple police reports regarding the same concern in a household.
I don't know if that was answered. No further questions.
I have the same objection Mr. McFarland is thinking about lodging. Police reports are hearsay.
And the reports are being used as a tool for the investigator to determine whether a case needs to be opened or a petition needs to be filed. So it's appropriate that if they are part of her report, then they should be admitted for that purpose.
I will refer back to the witness's only answers.
Yes, I am going to deny the admission of these particular records. We have established that record is clear that there were 2 incidents that were alleging domestic violence. And that was the reason for her actions moving forward. I think any further inquiry on this line would give the opportunity to perhaps misunderstand the purpose of what's contained in those reports.
I understand, Your Honor. Thank you. In addition to the police reports, you've also referenced in your testimony the PPO.
Correct.
How did you become aware that there was a PPO?
I honestly cannot remember.
Do you recall about when you were able to look at the petition for protective order or personal protection?
I believe it was about halfway through my investigation.
About when would that have been?
End of April.
And from the best of your memory, what in that petition, I guess, weighed in your decision making for the categorizing this complaint?
Once I had read the PPO that was filed, that was signed by Erica, I had concerns that she had not disclosed any domestic violence to me, but then had disclosed domestic violence to the shelter who in turn helped her write this PPO. That was filed and granted. Later on in the investigation, I had contacted Ms. Walker to talk about a family team meeting to schedule that, talk about services. While on the phone, I asked her where was she living at the time. She had stated that she was living at Harold's with Melanie. I could hear Harold talking in the background. And during that phone call, she had denied that she or Harold needed any services.
I'm sorry for the interruption, but while we're on this topic, was that during the period of time where the PPO would have been in effect, you know?
Yes.
Thank you.
In any of the other, like, were you able to explore any other records? I know that deep justice because kind of gets access to a lot. So were there any like medical records you're able to explore or mental health records or anything like that?
I didn't explore those. Both parents had denied any services in that capacity, but Harold did, when we had the family team meeting, he did talk about early on with Melanie, and he said they had went to the first meeting of early on services for her, and then they didn't go to any after that.
Based on your first report, which is dated or signed by you on May 13th, what was your disposition for the case at that point in time?
We had substantiated for, I think it would be considered placing a child at unreasonable risk for concerns of the ongoing concerns of possible domestic violence. The parents weren't telling me that there was domestic violence in the home. However, I did locate the PPO that was active that they were violating. I was actively trying to offer services that were not being taken into consideration for them to start doing. But the ongoing concerns of possible substance use also. I had asked both parents to drug screen and they both refused.
Did you speak with anyone else that might have, or did you have any other information that helped you form this opinion as well?
The history of domestic violence in the relationship, all the police reports I had read throughout the years, and the PPO. Reading the PPO was, I think, a big eye opener for me. And the PPO, it states that there was domestic violence in front of the child.
Did you speak to any other family members?
I did. I spoke to Harold's sister throughout the case.
And did any of the information she provided you weigh in your decision?
I would say it had a small impact. I definitely take opinions of family members, especially when they're close to the family. She had let me know that, you know, she was supportive of the family, that she had helped them build a fence for Melanie. They live on a busy road, cars go fast by there. So she had helped build a fence. Melanie is very active. So they had helped purchase fencing for them, put the fence up. They helped on the weekends, kind of with respite care, giving Eric and Harold a break. And they were supportive in that way to Erica and Harold.
Did she state that she had concerns for the child?
Yes.
What concerns did she have?
Objection, that would be hearsay.
Again, Your Honor, just asking for the information she used to formulate the basis of her decision.
Well, it's still hearsay. What did she say? I don't know how more hearsay you could have.
Hearsay is any statement asserted, out-of-court statement asserted for the truth of the matter asserted, I'm sorry.
Okay.
I'm not asking for it to be entered for the truth of the matter asserted, that whatever the sister said is true, but rather what formed the basis of Ms. Kelly's opinion.
Well, that's the case, and we don't need to know what she said.
Mr. Brooks?
I have no position on this.
Ms. Underwood?
I would echo what Ms. Thomas said. It's, again, not used for its necessary truth for your determination. It's used for Ms. Kelly to compile facts for her investigation.
I will allow it strictly for that purpose.
Yes, Your Honor.
There were concerns for domestic violence in the home and possible substance use, possible untreated mental health as well.
So once you make a case open under category 2, that doesn't require petition from the court, correct?
Correct.
So what happens after that?
The case is open to an ongoing CPS worker for services, and then services are provided to the family.
Did that transition ever happen? Did an ongoing CPS worker ever become involved with this family?
There was a family team meeting, that we completed with the ongoing worker and then, Harold. And then the case was never fully, I wouldn't say it was transferred, but it was not fully started due to the new investigation coming in.
And so the new investigation that came in, that would be the intake 1360205 or 0450.
Yes.
And what was that new investigation relating to?
That was relating to a possible domestic assault occurred between Eric and Harold on June 16th, 2024. It had stated that Harold assaulted Erica. Erica was holding Melanie when Harold assaulted her. Melanie was not injured. Erica did not sustain any injuries for the assault. No one was arrested. And then there were concerns that Erica smoked dope with Melanie present.
Okay. At that point in time, what did you do to investigate that complaint?
I obtained the police report that happened on June 16th. I believe it was June 16th, but the police report originated out of Madison Township, but then Raisin Township was involved also. Madison Township handled speaking with Erica, and then Raisin Township handled speaking with Harold at his residence.
And what information, so that's part of your investigation is looking at a police report, is that correct? Did you do anything else to investigate the complaint?
I tried to meet with the family. I tried to locate any other police reports that had happened in the previous month. I don't think there were any that had happened between June 16th and then when that case had opened for ongoing services, when we did like the family team meeting and that stuff. But in the beginning of the second investigation, that's when our concerns were really raised as, ongoing services hadn't really started, that Erica was still being uncooperative with meeting with the department, and there's still allegations being made and police reports being made that is saying that there's domestic violence in the home.
Was there anything else that from that specific incident that made you concerned for the child's safety or well-being?
In the allegations and in the police report, it talks about Erica was on the side of the road. She ran out of gas, and then she was hiding in a ditch with Melanie. It was late at night, and it talked about Erica's eyes were checked. There was no distortion of her pupils. It is unknown if Erica was under the influence at the time of the incident. I had concerns after reading the police report and the allegations that, the police had looked at her eyes and.
Your Honor, here I am stating hearsay again, because now it's being used for the truth of the evidence asserted, and that based upon what the police said, she's forming a belief of truth. Because the police noticed that the eyes were, not only do we have the report, now this is what the officer's saying, we're using that for the truth of the matter asserted.
All right, Your Honor, Ms. Kelly never said that mom was using substances.
No, she said the police officer said that her eyes were, and here we're getting into.
Well, if you would let me finish my statement, she stated that her concerns were for the child's safety, included the fact that the police officer checked for whether mom's eyes were dilated or not. Not that they were and she was using. Do not believe that this is hearsay, because again, it is not being used for the truth of the matter asserted.
Your Honor, I guess if it's not being used for the truth of the matter asserted, then it wouldn't have been used to bring this case forward. And to bring the case forward, it would have had to have been used for the evidence that she's testified to. It's not just extraneous information that's not relied upon, it's relied upon. So that's my position.
Anyone else want to weigh in?
I agree with Mr. McFarland.
I feel like the hearsay
exception is being not confused, but maybe misconstrued here. Again, Ms. Kelly can utilize any documents and information that she has to form an opinion on a case and use those things to determine whether a case needs to move forward. We're not asking that the police's statements are used in court today to be for the truth. What we're asking is, what is Ms. Kelly, was Ms. Kelly using to, again, figure out what's appropriate in this case when the petition was filed, when the case was being investigated, not for its actual truth. Ms. Kelly has to rely on statements from police, statements from people when determining what's going to happen in her investigation.
I agree with the reasons offered by Ms. Underwood, so I will overrule the objection. At this juncture, we do need to take a brief recess. Unfortunately, after I gave you this morning, had to schedule a couple of emergency hearings. So we'll need to take a break to handle those. What are the obligations that you have again this morning that may limit our time frame? Does anybody have anything they have to?
Your Honor, I was able to rearrange that,
Okay,
so I'm okay.
all right, so we'll.
I'm
take a-
scheduled for 3 mental health in front of this court, but only 2 will proceed.
That's what we're taking a break for, Mr. Brooks? You're
Free
limited.
as a bird, Your Honor.
Great, appreciate that. All right, so we're gonna take a recess then in this case and handle our emergencies and then we'll come back to move back on record. We have all of our attorneys and parents and parties. So Ms. Brittany Kelly coming up to back up to our witness stand. I'll just remind you to remain under oath.
Ms. Kelly, I believe that I just questioned you on the police report that you had received and reviewed as part of the second investigation. Other than that report itself, were there any other pieces of information that you reviewed or individuals you spoke with to investigate the concerns in that second complaint?
No, just based off the information from the first one I had gathered, I felt like I already had a lot of information regarding the concerns.
And you stated that filing the petition, I believe, I'm trying to recall from your prior testimony, that the ongoing services had not been started yet, the family was still non-cooperative, and then there was a police report. Is that accurate? Right. Okay. In order to file this petition, there has to be like concern for the child's imminent safety.
Correct.
What were your concerns?
My concerns were that I had received another investigation stating that.
For the child's imminent safety.
Correct.
What were your concerns?
My concerns were that I had received another investigation stating that there was ongoing domestic violence still in the house.
Your Honor, at this time, I would ask to move, sorry, Your Honor, ask the court to accept the CPS investigation reports that were drafted by Ms. Kelly.
Have they been circulated to your fellow attorneys?
Yes, Your Honor.
Gentlemen?
Asking for the caseworker's report to be submitted?
Yes.
No objection.
No objection except to any hearsay references, and I'm sure the court can pull out.
Thank you, and I will disregard any hearsay, or if there is anything in there, I will assume that it is not for the truth of the matter asserted, but rather to demonstrate whether or not Ms. Brittany needed to do something based on what she read. Ms. Thomas, is that a copy for me?
Yes, Your Honor.
Deputy Ames, would you like to move side to the bench? This will be Exhibit A. That's an applicant. Thank you so much. It is received. Oh, I think I have 2 copies. I think
No,
I have-
Your Honor, those are the 2 reports. There's one for the first complaint and the second.
Is that clear to you, gentlemen? There were 2?
Yes.
It is.
Ms. Underwood? Yes. Thank you. I appreciate the clarification. So we'll call them A and B.
Thank you, Your Honor.
Thank you.
Ms. Kelly, from your personal experience with the parents, do you have any reason to believe that the child would be in harm's way?
I'm sorry, I didn't hear the last part of your question.
I asked Ms. Kelly from her personal experience with the family, if she had reason to believe that the child would be in harm's way, and let me clarify, with it in the parent's care and custody.
I'm going to object on the ground and require speculation.
Can you repeat the question?
I asked Ms. Kelly, based on her personal experiences with the family, if she believes that the child would be in harm's way in their care and custody.
Mr. McFarland, do you have any objections?
I support Mr. Brooks, plus I don't think she, yeah, I support Mr. Brooks' position.
Ms. Underwood.
I believe it calls for speculation as it's based on our experience with the family.
And maybe we need to hear what the experience is.
Ms. Kelly, were there any other interactions other than the ones you've already described that would have helped you form the conclusion to the question you're being asked?
If you're asking me about like my interactions with the family, if there was concerning behaviors, yes.
So were there other, because you've talked a lot about your interactions with the parents so far. Are there other instances that you haven't talked about that would help support your conclusion?
I haven't personally talked about them. They were brought up earlier in other testimony though. The phone call with Mr. Hollis and the face-to-face visit I had with him, letting him, or he told me that we would have to kill him and get through his dogs to find his daughter. And then the phone call with him, he said that he took Melanie away and we would never be able to find her, which is concerning. I didn't know where she was. We had already had a court order, and I didn't know exactly what he meant by that.
Does it matter if you personally have risk, concern about the risk when you were in the capacity of performing your obligations as an investigator? Or is it a more objective criteria that you then have to apply to a situation?
More objective.
So can you give me a couple of examples of that? What are the criteria that you have to use from a professional basis that helps you determine whether or not there's a risk of harm to the child? Are there certain things that you're asked to look for during the course of your investigation?
If there are issues in the home that that would arise to the concern of her well-being, which is a multitude of things. I guess I don't know what you're asking specifically.
That's okay. Well, Ms. Thomas is asking if you personally think there was a risk of harm. And I think that the objection is speculation, which I think I would have to overrule the objection on the grounds of speculation. But I'm more interested in professional reasons that you have concern rather than your personal ones.
I think that showing up as a professional and trying to speak to parents about the concerns that are being raised in their home, I think their interaction with me says a lot. I think all the documentation that we receive throughout an investigation says a lot. I don't have any personal opinions, just, my personal experience as a professional going to their home, I formed opinions on, but not my own personal beliefs or anything like that.
All right, thank you for clarifying. So I'm going to overrule the objection on the grounds of speculation for the reasons I've already shared during my dialogue with the worker. And she's also answered the question in the course of that. So.
Yes. And I have no further questions on this, Kelly. Thank you, Your Honor.
Cross-examination, Mr. McFarland.
In many of your investigations, you're familiar that many people are of the opinion that Child Protective Services, CPS, is there to take our child. You've heard that expressed, correct?
Yes.
And if that's were the case in this matter, parents might be reluctant to talk to a CPS worker, correct?
Correct.
As a matter of fact, there's no order compelling them to testify, correct? There's no court order saying that they have to talk to you when you were out there trying to talk to them, correct?
Correct.
As a matter of fact, you are a mandated reporter through the state of Michigan for child abuse, correct?
Correct.
And there's an allegation here of domestic violence, correct?
Correct.
And if during the course of your discussions with either father or mother, they revealed something such as they actually did have commit child abuse, you would have to report that, correct? As a mandated report.
I think while I'm actively investigating it, I would address it as the investigator in the
Sure.
case.
Okay, okay. Might need to pass that information on to law enforcement, correct?
If there's allegations of child abuse, yes, there's policy that says law enforcement is involved.
And you would agree that they have a constitutional right against self-incrimination, which means they can remain silent, correct?
I believe so. I don't know the law that well.
Oh. So it sounds as though, correct me if I'm wrong, but the principal reason why we're here is because parents didn't wish to cooperate, at least my client didn't wish to cooperate or talk to you. Is that correct?
Correct.
Which may be her right to do, but then your right is to go ahead and file what you've done, correct?
Correct.
Okay. You've heard my client testify, and says she read text onto the record that she requested that she confer with an attorney before discussing the matter with you, correct?
Correct.
Is it true that your response was what we're discussing would not need an attorney, correct?
Correct.
You go to law school?
No.
Think you really give legal advice that you don't need to have an attorney?
I was simply stating that an attorney was not needed for me to speak with her in my capacity to do my job.
Well, even though what they might say might incriminate them, correct?
And I'm gonna object. Miss Kelly has already stated that she's not a legal professional. Furthermore, I also think that Mr. McFarland's application, or I think he's trying to make an argument about constitutional rights, does not expand to CPS investigations. It's relating to self-incrimination in any court proceeding. I don't believe that a CPS investigation is a court proceeding.
Not correct, Your Honor. It's practicing law without a license, giving legal advice without being an attorney. But I have no further questions.
Mr. Brooks, any cross-examination?
Please. Ma'am, to your knowledge, is Melanie a special needs child?
I'm unaware if that's true or not.
You're not saying yes, you're not saying no.
Correct.
Thank you. Do you know if she's been diagnosed as failure to thrive?
No.
All right. No, she's not a failure to thrive child, or you just don't know?
I don't have the information.
To your knowledge, has she been diagnosed as having suffered any physical injuries that are suspicious?
There were allegations that she was involved in these incidents, but I don't have any, I didn't see any injuries on her the one time I saw her briefly.
Does she appear to you to be a normal, healthy child from what you've seen?
I don't think I can make that determination based on the time I spent with her.
Do you see any red flags? You go, uh-oh.
She was running around on the porch. She wasn't verbal, but I don't know if that was because I was a stranger, or there could be a lot of different factors as to why she wasn't talking to me. But she was physically active, that's a good sign in her age.
She's 2 years old, right?
Yep, I think she's both 3 in December.
I have no further questions.
Ms. Underwood?
The one time you saw Melanie running around, or I'm sorry, the minor child running around, excuse me, were Mr. Hollis and Miss Walker together?
Yes.
And that was the time in which a PPO was in effect?
The PPO had not been served. I believe it was served later that exact same day that I was there. I was there in the morning hours and it was served in the afternoon, but it had been signed by the judge prior to that.
Okay. And so Miss Walker had, to your knowledge, left the home and then returned to the home?
Yes.
Your job as an investigator is to try to provide parents with tools and services to avoid removing the child from the home. Is that correct?
Correct.
And you feel like, is it true that you felt like this petition needed to be filed because there had been very little cooperation from the parties?
Correct.
Was it the totality of your investigation from the police reports to the PPO to the lack of cooperation that made you make the determination to file the petition ultimately?
Yes.
After Ms. Walker indicated she wanted to speak with an attorney before contacting you back, did you ever hear from her again?
I believe it was the same day we had the conversation, that we were texting and, we were trying to schedule a meeting. I had texted her and told her I could meet anytime before 2. I was actually off of work that day. And I was texting her throughout the day, still trying to get her to meet with me. And I told her anytime before 2 I could make happen. And I believe she texted me after 3 o'clock that day to see if I could meet with her, which I was not on my phone anymore. I was dealing with stuff in my personal life.
Okay. At one point in your investigation, Harold had indicated that Erica was smoking dope. Is that correct?
Correct.
And that was a concern, that another additional concern you had?
Yes.
I don't have any further questions. Thank you.
Any redirect?
No, Your Honor.
Any recross?
No.
Yes, based upon the GAO's line of question.
Go ahead.
If I heard you correctly, it was not because you could substantiate neglect or abuse, but because of the lack of cooperation of parents is why this petition was filed. Is that correct?
I'm going to object, Your Honor, that mischaracterizes the question I'd asked and the testimony presented.
I don't think it does. Question was, the parents were not cooperating. So I'm just trying to get some clarification on that.
What did you say the question was?
Sure. Is it true that you were not able to substantiate abuse and neglect, but it was because the parents were not cooperating with you that you filed the petition?
And I objected because it mischaracterizes the testimony. The testimony was that it was the totality of the circumstances.
I'm asking the client to testify. That's not what I heard, so I'm just asking for clarification from her.
Are you using substantiate in the technical way that would be applicable in an investigation?
Let me rephrase, Your Honor.
Okay.
Was this case filed, I think you testified that this case was filed because the parents did not cooperate. Is that true?
And more allegations were received regarding the same concerns.
The allegations were received, but you weren't able to prove the substance of these allegations. Would that be true?
Due to lack of cooperation, yes.
That's exactly what I need to know. Nothing further.
Anyone else have follow-up questions?
No.
No, Your Honor.
No, Judge, thank you.
Thank you for your testimony. May I return your seat? Any other witnesses, Ms. Thomas?
Your Honors, Ms. Francesca Madrid on Zoom.
Yes.
Your Honor, I don't know if this is appropriate in a sidebar. Part of the issue that I have is that we were able to finally get the child's trauma bonding assessment report, but the clinician who provided it to us is not available to testify today. And we just got it, and then Wednesday when I circulated it to the other attorneys, or might have been yesterday, what the agency did. So I was going to ask Ms. Madrid to provide testimony on parenting time, but she is not the individual who drafted the report.
So As it relates to the records received from Renee Moore and this proposed exhibit, to me, those are sort of separate issues from what we're dealing with on the question of adjudication.
Yes.
So those would only be applicable if I decide that adjudication is appropriate. So I'm open to the arguments of the other attorneys on this point, but for that report, as well as the reports completed by Ms. Renee Moore, I would need to disregard those for purposes of adjudication. So I'm not sure if we need to enter that today unless, and we have time after the adjudication.
So that's, I guess, part of my question is I don't know if that's appropriate even at this time, and then if so, I don't have the person who wrote it.
Thoughts, Mr. McFarland?
I would agree with the court. It's not appropriate for the adjudication trial. If the court does take jurisdiction, review it for the detail.
Mr. Brooks?
I agree with the court. If you can't use it for adjudication, why do we waste our time dealing with it today?
Ms. Underwood?
I think, Your Honor, what you've indicated is reasonable, and we can reserve it for potential further hearings if needed.
Right, very good. So I'll ask you to do that, Ms. Thomas.
Absolutely, thank you, Your Honor. With that, I do not have any other witnesses.
Any witness testimony today, Mr. McFarland?
I have one. I've notified everybody from my witness, Laura Walker.
Ms. Laura Walker, any objections? I know there was a discussion about the witness list.
No objections, Your Honor.
Any objections?
Okay. All right, come on up to your witness stand.
Laura, you're my client's sister, correct?
Correct.
Biological sister?
Yep.
Oh, okay. Where do you live?
I live in Fayette, Ohio.
Okay. How often have you visited, let's say, within the last year with your sister and the child?
Before she left the home.
Correct.
Which home?
Before CPS took her.
How about before CPS involvement?
Wait, I'm sorry, I'm confused. The child or her sister? Who's?
Okay,
Let me rephrase.
okay.
Have you seen the child within the last year with your sister?
Yes,
Have you seen the child with Mr. Hollis?
yes.
How frequently have your visits been, and tell us the duration about how long they've been? How often did you do them?
Probably 4 or 5 times a month.
Okay, and for how long were these visits, would you say?
It just depended on if I was going to the house to get Melanie for overnight or just for a visit or a holiday.
In and out, or a little bit longer chatting?
Yep,
Which?
yeah,
Or both?
hours.
Okay.
Hours.
Did you see the interaction between my client, father, and the child?
Yes,
I don't want to use the child's name because we're on the internet, okay?
Yep.
Any alarm bells that rang off in your mind that this child may have been neglected or abused?
No.
You heard the testimony presented that there may have been domestic violence, correct?
Correct.
Did you witness any of that?
No, I did not.
Did either of the parties ever tell you that there had been domestic violence?
No.
Did you ever have any concerns with the child, with your sister or the father?
Never.
You had concerns, what would you do? Did Protective Services reach out to talk to you about your observations?
Only the day when they came and got her.
Okay, and who did you speak to?
Jill and another lady.
Okay, talk about Jill Tipton, who's sitting behind us. Anybody else here that you spoke to?
No.
What did they ask you?
They came in.
Objection,
Melanie was-
hearsay.
Well, Ms. Tipton is here, Your Honor. So, and I don't know how it's really hearsay. It's not being used for the truth of the matter. I'm just asking what was the question asked. So we're not asking to form a conclusion. We're just asking what was the questions that were asked. Let me rephrase. Did you give any answers to workers?
They asked you some questions, you said, right?
Yeah,
And you told them some statements, right?
no,
What did you tell them?
that Melanie was with me and they asked me to take her over state line to drop her off in Michigan.
Okay. And why was Melanie with you?
Because the day before, Erica had called me and kind of filled me in on some stuff that was going on about CPS, and I told her to bring her to me. It was quite often that I did keep her overnight.
You jumped ahead of me.
We were very close.
And you jumped ahead of me if you've ever babysat for her.
Yeah, yes.
And were you ever babysitting because you were told there's domestic violence or something like that and
No.
they needed a break?
No.
Okay. I have no further questions. We'll see if anybody else has questions.
Ms. Thomas?
Thank you. Ms. Walker, you stated that you spoke with Ms. Tipton,
Yes,
and isn't it true that you told her that both Harold and Erica were having methamphetamine and probably used as recent as the day before you spoke with them?
no, I told them that I hadn't spoken to Erica for like 6 or 7 years, and there was speculation that they were doing drugs then, but I didn't think that they were now, since Melanie.
And isn't it true that you stated that you and Erica are not close?
Again, for 7 years, we didn't speak until after she had Melanie. But then after that, we were.
You stated that Erica called you the night before the child was found in your care and told you what was going on with CPS. What was your understanding of what was going on with CPS?
She felt like she was being harassed and that all of a sudden they wanted to take Melanie, and I didn't really know what was going on.
Were you aware that there was a court order for
No.
CPS?
No, not until the girls came to the house.
And is it your opinion that CPS should have no valid concerns to remove the child from the parent's care and custody?
Sorry, can you repeat that?
Is it your opinion that CPS has no valid concerns for removing the child from her parent's care and custody?
Yes,
Isn't it true that you told me that mom has a long history of mental health illness?
I told you that.
Yes.
When did I speak with you? I'm sorry, I don't remember.
Were you present at the preliminary hearing on June 27th?
Yeah.
And we were in a referee hearing room. Do you recall that?
What's the question again?
Do you recall being in the referee hearing room in this courtroom with Judge Costello for that hearing?
Yes,
And isn't it true that that mother had a long history with mental health?
yes, yes.
And have you witnessed any of her mental health concerns affecting her ability to parent?
No.
Thank you. I have no further questions.
Mr. Brooks, any questions?
I do not.
Ms. Underwood, any questions?
You indicated that you told Erica to bring Melanie to you in Ohio
Yes.
after CPS was involved.
Yes,
Were you attempting to help conceal the child or hide the child?
I didn't know what was going on. I wanted her anyway. That's why that was mostly what our conversation was about that day anyway. I actually called her and I wanted her for overnight anyway.
So you didn't believe that taking Melanie was helping conceal the child from the authorities?
No, because I really didn't know what was going on at that point.
Did you think to maybe ask what was going on before just taking the child? You can look, I don't want you looking at
Oh,
the witness or at the parties when they're testifying.
she was crying. She was a mess. I didn't know what was going on. She was very upset, sad. She felt harassed. She kept saying, they're trying to take my baby. And honestly, at first I thought she was talking about Shirley, Harold's sister, because it's been an ongoing thing since the beginning of the year.
So after she said they're trying to take my baby, you said, bring her to me.
Yes.
Does Erica have any physical limitations that inhibit her ability to parent Melanie?
Well, she walks with a cane. But it doesn't slow her down. Of course, it slows her down, but we have a lot of disabilities in our family. We've always learned to keep going. My mom raised 7 kids in a wheelchair. You know what I mean? That's just how we are. Keep going. No matter what, it doesn't matter if, you know, I don't know. She has a hard time walking, but she still does it.
Were you aware that there was a PPO between Erica and Harold?
Yes.
Were you concerned about Erica's safety after she put out a PPO against Harold?
I just didn't know what she was going to do.
Can you clarify? Were you concerned with Erica's well-being after being made?
I'm sorry, financially alone, not being with mommy and dad.
I'm not following your answer.
I didn't really understand what the PPO was for exactly. I just knew that she was staying with a friend, Jill Hinkley, and her husband, and trying to figure things out, and then they had it dropped.
You understand that the PPO was in place for 4 months?
Yes.
And Erica has never confided in you about any physical abuse from Harold?
No.
Did she ever call you when they would get into fights?
No.
I have no further questions. Any redirect?
No, thank you.
No.
All right, anything for us, Ms. Thomas?
No, Your Honor.
Thank you for your testimony. You may return your seat.
No further witnesses.
Mr. Brooks?
No.
Ms. Underwood? Did you have any witnesses?
No, Your Honor, thank you.
Okay.
Closing arguments, Ms. Thomas?
Thank you, Your Honor. Been pretty honest with this court and fellow counsel about the disdain I have for the statute that requires us to file petitions and we don't have cooperation from parents. Because it puts us in this evidentiary issue for trials. What can we prove? The workers are trained to look at the risk of harm for children based on the evidence that they do have available to them. When there are parents who are unable or unwilling to open their homes to talk with CPS workers to reassure them that their children are safe, to demonstrate that their children are safe, CPS workers have to do exactly what Ms. Kelly did. She had to rely on the information available to her through police reports, family contacts, and how she was treated by the parents. And this court must find by preponderance of the evidence that at least one of the allegations in the petition are true to the extent that there's been a violation of the juvenile code. Throughout the trial, the parents' testimony has attempted to diminish the concerns about their relationship dynamics and what the child has been exposed to in her short period of life. The dynamic of protecting one another is exactly the issue that Ms. Kelly ran into during her investigation as well. Nothing was clear in her investigation. There are potential things that may or may not have been true. We're not sure if Ms. Erica Walker was telling the truth during her testimony in court, or whether she was making false police reports, or if she was not telling the truth to community members like Catherine Cobb Domestic Violence Shelter to wrongfully utilize those resources and waste them on a family who does not actually need them. We don't know if she filed a false PPO, so essentially lying to the court. We have no idea what is true. her testimony is that all that information only exists because she was angry with him for saying he was going to take their daughter. And Mr. Howell's testimony was he was angry with her at times for taking their daughter. Both of them denied any anger management issues, yet we heard a phone conversation in which Mr. Hollis was pretty aggressive. We have the CPS reports and that have been admitted into record in which Mr. Hollis is telling law enforcement and CPS to get the fuck his property and lunging at them and being aggressive in that way. We have a lot of indications that that's not true. And the blame that the blame that we are hearing is being shifted, I guess, or the responsibility of CPS becoming involved is being shifted to Mr. Hollis's sister. That Mr. Hollis's brother and sister simply just didn't like Miss Walker, or that they're trying to take their child. And even if, like, we don't have proof of that, though, we're just hearing what they say. Even if that were true, I guess, maybe those concerns from the family members were valid. Maybe there should be valid concerns for the safety of this child, especially from an individual who lives there with them, or an individual who also is helping build a fence around their home. Like, that seems very interesting to me. So we have this child who, at worst, if we accept all of the information that Ms. Kelly had as true, at worst, this child has witnessed and experienced domestic violence while in the arms of the same individuals who are charged with protecting her. And at best, if none of that information is true, and we believe the testimony of the parents and Ms. Laura Walker, this child was in an environment with parents who would argue or get angry with one another, make up lies about one another, and use her as a pawn piece, threatening to take her away or actually keeping her away from the other parent. All of those things, whichever way you look at it, clearly pose a risk to the child's physical health, emotional health, or mental well-being. And for those reasons, I believe that this court can find by a preponderance of the evidence that the juvenile code has been violated under MCL 712A.2 A and B. Thank you.
Mr. McDonald?
I come up here for the court and see me. Your Honor, our Constitution really has no legs unless it protects activity that people may not appreciate, may not like, might be disgusting to some. My client has an absolute right not to speak to protective services. She has an absolute right not to incriminate herself. So yes, we concur that Child Protective Services has a right then to go ahead and file with the court here. We may not like parents arguing. I can see where if parents thought that their child was going to be taken from them, how they might use language which might be offensive, which is still protected speech, Your Honor, under the First Amendment. When we've asked the worker here what she was able to determine for abuse, they really haven't been able to determine abuse. There's a PPO asking my client under oath about that. Obviously, she didn't know what narcissistic meant. She didn't know what gaslighting meant. She was awoken in the middle of the night, asked to fill this out by Catherine Cobb. It appears to be part of her staying there. That's what has to be done. But she indicates that she was ticked off at the father of her child. Thought that he was going to take the child, so she did that. We've heard testimony from the father of the child, Mr. Hollis. He thought she was going to take the child, so he was making remarks about her. Still, even if these things happened, we have no testimony that this child was in harm's way, that the child was neglected, that the child didn't have food, the child didn't have shelter, the child didn't have appropriate care. We don't have proof of abuse, Your Honor.
So what if parents were arguing? Parents argue all the time. I don't know of any couple that have a child in common that don't argue. Does that mean that we need to have involvement of CPS? No. If a child was present while they were arguing, we still don't have evidence that there was harm to the child. We don't have any evidence that the child knows what the conversation is, and I doubt that a 2-year-old knows the vocabulary, knows what's going on, or we don't have even testimony that the child was present in the room or could hear. It's just absent on that, Your Honor. You're looking at a preponderance standard. I don't see by preponderance that we can demonstrate abuse or neglect. We can demonstrate that clients exercise their constitutional right. Under oath, here in court today, she testified that what she said, what was mentioned in the PPO, which she did not write, was not true. She was doing that to get back at Mr. Hollis, what she thought was going on. We also heard my client's sister, who appears to be truthful today, who doesn't know of any issues of abuse and neglect, who says that after this child was born, her sister turned her life around. We don't have any evidence of drug use. So don't have any true evidence of mental health neglect on my client's part after this child was born. I just don't think we have enough here, Your Honor. I'm sure this case, these parents are going to be monitored for any future calls, any future concerns, but I just don't believe, based upon the proof presented, that we can say by preponderance, abuse and neglect, that this petition can be substantiated. Thank you.
Mr. Brooks?
About 10 years ago, there was a hit comedy show on TV. It was called Seinfeld. It lasted 7-8 years. Lasted a long time. That show, they were proud to say, was premised on nothing. Somehow they made that into something. I submit this trial is premised on nothing. No evidence of the child being injured or harmed in any way. There's no evidence of malnourishment. There is no evidence of failure to thrive. There's no evidence of domestic violence, other than Mr. McFarland's client saying she admits she lied about it. There doesn't appear to be any injuries apparent on the mother. All you got is somebody somewhere, and I don't know who they were, accusing these people of having a domestic violence which is threatening the child. But they weren't in here, were they? I never saw them. I never heard them. I see that the prosecutor or the attorney for the department has practically turned herself inside out trying to get hearsay type evidence in for the last 2 days. Why would she go to that trouble? Because there's nothing else. It's air. Sometimes, yes, they would have the right for my client and the mother of his child refusing to cooperate, but you still got to prove it. That raises an alarm for review by the court, but you've still got to review the evidence, and there is none. I ask that you dismiss this case.
Ms. Underwood?
Your Honor, this petition is not indicating that the child was physically abused. The petition is indicating that the child was put at a substantial risk of harm because the parties were involved in a long-standing domestic violence relationship. which was evidenced, again, Miss Walker testified that she did call the police saying that Harold had abused her while Melanie was in her arms in 2022. There was another police report that Erica herself did testify to, stating that she told police that she had been physically assaulted, punched in the jaw by Mr. Hollis. She then signed a PPO with allegations that she admitted to telling the Catherine Cobb workers that are incredibly similar to what she testified to regarding what was stated in the police reports. Your Honor, people don't go through the trouble of contacting police multiple times, seeking refuge from domestic violence shelters, and trying to escape domestic violence only to state that it was all a lie. That in and of itself is concerning to me as a GAL. And again, CPS needed to rely upon the PPO and the police reports and the evidence that was presented or provided in order to file this petition. And again, Erica's testimony stating she was lying. I mean, she's not a credible witness if she was willing to go through all of these lengths. She also testified that Harold was a changed man as soon as Melanie was born. Mr. Hollis indicated that Erica was smoking dope, so there are concerns there with substance use, along with the fact that Erica admitted herself to not being willing to submit to a drug screen as requested by CPS. Again, CPS was there initially to attempt to help this family and provide them services so that they could provide the minor child with more stability and less harm. However, the lack of cooperation, along with the other allegations in two different investigations, left Ms. Kelly and the department no choice but to proceed with this petition. Ms. Walker's sister has indicated that she was aware that CPS was involved and told her sister to bring her across the state line to her home when Erica indicated that they were trying to take her. That is concerning as well. Ms. Walker deliberately kept the minor child from CPS when they attempted to just do a well check on her and make sure she was safe. While Mr. Hollis was somewhat cooperative, he continued to willfully violate the PPO that was in place up until August of 2024. It's my belief that Ms. Walker is probably not comfortable telling the truth in front of the court when the perpetrator of her violence is sitting right in front of her during her testimony. I am very concerned for the well-being of this child, considering all of the facts and circumstances surrounding this petition. I think it's in the best interest of the child to be in the care of relative placement while this family receives some services to help become better parents for their child. So I believe that preponderance of the evidence standard, more likely than not, I believe that the department and the witnesses presented more than enough evidence to hit that preponderance of the evidence standard, both for Harold and for Ms. Walker. Thank you.
Well, the court finds all interested parties were given notice for purposes of today's hearing requesting adjudication. We did, of course, continue this for Tuesday in order to make sure that all of our witnesses had the opportunity to testify and all of our attorneys had the opportunity to ask any questions they may want to ask. Ms. Underwood is correct when she references that the standard here is a preponderance of the evidence as to whether or not the aspects of the statute have been violated. And in this case, it is the sections 1 and 2 that Ms. Thomas referred to. That is whether or not the home or environment created by the parents is unsafe to the child, presents a substantial risk of harm to her mental well-being as a result of neglect or refusal to provide proper and necessary support, education, medical, surgical, or other care necessary for the child's health or morals. In section 2, whether or not the child's home or environment with the respondent parents by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of the parent is an unfit place for the juvenile to live in. The parents failed to cooperate, but also didn't fail to cooperate in many ways. They did have some interactions with the department that demonstrated some of the concerns that were brought to light during the trial today. And some of the concerns that I think probably caused, obviously, there to be a complaint made to the department and a request for investigation. There were concerns that arose to the level that required police response. We heard about 2 different incidences, I believe in April, and then there was another one during the course of the investigation in June. So I've heard the story from what Ms. Kelly was able to put together, and I, of course, have heard the testimony of both parents. I've been able to listen to that voicemail that was produced by Ms. Thomas. And what I've been able to put together as far as the findings is this. Ms. Erica Walker seems to be, who is the primary caretaker of this child, calling in police or being at least part of police intervention for what she's claiming and what they are claiming as domestic violence incidents. She then leaves the house and either seeks shelter at Catherine Cobb or couch surfs, and Mr. Harold Hollis may or may not know where she is. I believe him when he says that when the cops came to his house that he had not seen her in days. And I think she substantiated that as well, at least in part during her testimony. So we have here either a very unstable parent who at any point in time is just willing to simply up and leave the house and couch surf and lie to Catherine Cobb about domestic violence and lie to police officers about domestic violence and lie about the fact that she may have been being chased by Mr. Hollis, or we have a very unstable woman who is willing to say these things and take a very young child with her as she does go through these particular episodes where she is very clearly in fear for herself. Whether that's realistic or not, that's really concerning as far as a primary caretaker role for this child. So I think there's clearly a preponderance of the evidence here that Ms. Erica Walker has created an environment for her child that's unsafe. The only demonstration of housing stability that we've seen here is when she stays with Mr. Hollis. And when she's gone, he doesn't know where she is. And it was unclear from her testimony where she is or where she has been. Whether she's couch surfing or ending up in shelters. At one point, she ran out of gas on the side of the road and was in a ditch, apparently. There's no indication that I don't know where she is or where this child is at and whether or not she's safe. So the other piece to that too is that this child seems to have qualified for early on services and was not being submitted for those by either parent. So I do see there's a preponderance of the evidence here as it relates to Ms. Walker that in her care, there is a neglect of the medical care necessary for the child, and that there's a substantial risk to her mental well-being. We take it around with Ms. Erica Walker during these episodes, and that is in a home or environment with her because of that same neglect and potentially criminality, including lying to the police, lying on a PPO application, lying to representatives of Catherine Cobb. That creates an unfit place for this juvenile to live in. And whether it's because her allegations of domestic violence are true, or whether because Mr. Hollis simply fails to take action when Ms. Walker goes AWOL with his child, there is certainly a preponderance of the evidence here that if entrusted to provide an environment where this child, I should say, receives the medical care she needs through early on services, the regular doctor's checks, and to ensure that she's safe from a person who is either around a domestic violence situation or is in the primary care of a woman who is very unstable, whether that's from substance abuse or untreated mental health issues, and allows that to be part of his home or environment where this child is supposed to be living safely. So I do think there's a preponderance of the evidence as it relates to both of these parents, and I am taking jurisdiction. We're going to set a disposition date, and it's going to be the immediate order of the court. The referral will be made for a psychological evaluation right away for both parents, so that at the disposition, I can understand more clearly what the issues are that are plaguing this family. Clearly, we have potentially issues of domestic violence, or at least the dynamics of domestic violence in the home, and I would harken back to Ms. Underwood's observation, which I also made, that Erica said he's a changed man since we got married. Well, what does that mean we were before? And people simply don't change overnight. We have all of the police reports and those allegations. So at a minimum, we have these dynamics in place. And I want to know why and what we can do to help this family move forward past those to create an environment where the two of them are safe, able to avoid arguments, and that the child has a good, safe environment where she's going to have needs met. So let's schedule a disposition. Between now and then, the two of you will be asked to work with a case, to work on a case services plan to identify the things that you want to work on in order to improve the environment for your child. And we'll come back together and look at that within 28 days. It puts us in the first week of October. Looks like what I have available would be Friday, October 4th at 1:30.
Yeah, I'm not available.
Are you gonna be out that weekend, or can you tell me which days?
Just Friday, I just can't.
Okay, thank you. Well, that's all right, I appreciate you letting me know that. I'm gonna put a note here so I don't try to schedule you again. May have to move it up a little bit, which I know puts a little pressure on our caseworker to get that done. But I'm not sure there's any other way to do it within 28 days.
Hunter, may I say, I believe our 28 days would, I think, would be October 11th. I don't know if we have any availability in the afternoon, Monday the 7th.
I do, at 2:30. Any objections to that, gentlemen?
No,
That's a
What was the
pre-trial
time?
day in circuit court, so I have a lot in the afternoon that day, unfortunately.
no.
Is 3:30 a better time?
I have them set for 3 o'clock, so it's possible, but certain I could do any time in the morning that day. We have a review at 1:30.
Okay, so how about, let's see, I think I may be able to do 9 o'clock on October 7th. Are you all available? I know Mr. Brooks prefers 10, but that's already taken.
October 11th at what time?
I'm sorry, it'd be October 7th at 9. So Monday, October 7th at 9 for our initial disposition.
I'm fine.
All right, so that's when we'll be back. All prior orders remain in full force and effect, including that directive to begin that supervised visitation for both parents. And Ms. Renee Moore did say she was available, at least for Mr. Hollis. So if you could please ask her to be involved with the parenting for both of these parents and getting some services around to assist them with parenting and parenting education while they're parenting would be great if possible. And I'll see you all back here on the 7th at 9 for our initial disposition. Unless there's any questions, that's all for today.
Has supervised visitation for my client been firmed up with the department?
Well, it's being ordered, and I know the child is out of state at the moment, but as soon as she's
Oh,
back.
that's right.
Yeah, I think as soon as she's back, I'll be looking for a time to set up an FTM to organize that.
Your Honor, I would just ask that Ms. Walker schedule and attend her first appointment with Ms. Moore before supervised parenting time begins for her.
No,
That was ordered by by Judge Costello in a prior order.
no.
I would say that could be done in conjunction with her first visit. If Ms. Moore can accommodate that. And I'm sure she'll continue to be able to tell us her thoughts on the safety and skills of the parent during visitation. So I won't prohibit it, but I will ask her to complete that, any assessment that Renee Moore wishes to do in conjunction with her supervised visits.
Are their visits going to be scheduled separately then, Judge?
Yes. I should say that, yes, too. I'd like the parents to visit separately so that we can look at the parenting skills of each independently. Any other questions, objections?
Just know my client's asking me something, what?
Should my client wait in the hall for an order or email?
Not today. We'll have to wait for it to come.
And we're off the record, maybe we can get an address and email.
I think we did that last time.
Well, we're not gonna get an additional testimony or something like that.
All right, okay, sounds like we're done for today. I do have one more I have to complete, so I appreciate you all.